Welcome and thank you for joining us for the first episode of the new year of Kelleher and Holland's Employment Law Lunch and Learn webinars. I'm Amy Rizzo. I'm the webinar moderator, and if you have any questions at any time during the presentation, please submit them through the Q&A button on the Zoom control panel. And depending on time, we'll try to answer them live, but we have a lot of information today, so most likely we'll follow up with you via email directly after this presentation. And as I just mentioned, today's topic is information heavy, so we will have some more detailed materials available after the webinar, and I'll talk a little bit more about that later. Our panelists today are from our employment law group. We have Andy Bowling, Maura McBreen, and Madeline Kelleher. So let's start by discussing the key updates that Illinois employers should be aware of in 2025. And if we have some time at the end, we will review some of the new laws that went into effect in 2024, just in case they remain unchecked on your internal compliance to-do list. So Madeline, I will hand it over to you.
Great, thanks, Amy. So there are a plethora of new federal and Illinois laws that became effective in 2024 and as of January 1st, 2025. And so with a grand total of 293 new laws that went into effect on January 1st, 2025 in Illinois alone, it would be impossible for us to get to all of them today. So today we're going to touch on the most significant employment-related laws that we believe everyone should be aware of. So let's get started. We'll first talk about the Illinois increased minimum wage. So minimum wage in Illinois increased $1 per hour to $15 per hour for workers 18 years or older, and to $13 per hour for youth workers, so those under 18, who work fewer than 650 hours per calendar year. Additionally, the minimum wage for tipped workers is now $9 per hour. Next, the Illinois Freedom to Work Act has extended the non-compete and non-solicitation restrictions to address specific professions. So now, covenants not to compete or covenants not to solicit cannot be enforced on any mental health professional providing mental health services to veterans and first responders if the restriction is likely to result in an increase in cost or difficulty for any veteran or first responder seeking mental health services. In addition, the Illinois Freedom to Work Act now prohibits any covenant not to compete or covenant not to solicit with respect to construction workers, regardless of whether an individual is covered by a collective bargaining agreement. Moving on, we have the Illinois Human Rights Act, which was amended in 4 significant ways. First, it is now unlawful for employers to discriminate against or harass employees based on their family caregiving responsibilities. The legislation adds family responsibilities as a protected class, making it unlawful to refuse to hire, deny a promotion, or discharge an employee based on the employee's actual or perceived responsibility to provide personal care to a family member. Also, second, Illinois employers are now prohibited from discriminating against employees for actual or perceived reproductive health decisions. So the law now defines reproductive health decisions broadly as a person's decisions regarding the use of contraception, fertility, or sterilization care, assisted reproductive technologies, miscarriage, mistreatment, or miscarriage management care, healthcare related to the continuation or termination of pregnancy, or prenatal, intranatal, or postnatal care. While this law does not explicitly impose any new leave or accommodation requirements on employers, employers should definitely be mindful of their employees' rights to be free from discrimination on the basis of any reproductive health decisions. Third, the Illinois Human Rights Act was amended to set the statute of limitations deadline to submit an alleged civil rights violation with the Illinois Department of Human Rights was extended from 300 calendar days, which has been for quite some time, now to 2 years. So you have 2 years to file a civil rights violation with the Illinois Department of Human Rights. Lastly, the employers are now prohibited from using artificial intelligence, or AI, to discriminate in connection with employment decisions and requiring employers it now requires employers to notify employees when AI is being used for any employment-related reason. Next, we have the amendments to the Illinois Whistleblower Act. This act was amended to expand the definitions of employer and employee while clarifying the definitions of adverse employment action, public body, retaliatory action, and supervisor. So additionally, employers are now subject to greater penalties for retaliating against employees for disclosing their employer's potentially unlawful activities pursuant to this Whistleblower Act. We have next the Illinois Wage Payment and Collection Act, which was amended to require that employers maintain copies of an employee's pay stub for at least 3 years after the date of payment, regardless of whether the employee's employment ends during this period. So that's a record-keeping requirement, 3 years for all pay stubs. Additionally, employers must now provide pay stubs to current and former employees upon request within 21 calendar days. So next we have the Illinois Equal Pay Act, which was amended to require that employers with at least 15 employees to include pay and scale benefits information in all job postings, both internal and external. So the law defines this pay scale and benefits broadly as, and I quote, the wage or salary range, and a general description of the benefits and other compensation that the employer reasonably expects in good faith to offer for the position. Also, employers are now required to announce, post, or otherwise make known all opportunities for promotion to current employees no later than 14 calendar days after making an external job posting for the same position. So this means that within 14 days of posting a job posting online, you have to give that job posting or make all current employees aware of that job posting. So that's an interesting one. Employers who fail to comply with the pay transparency mandates will face penalties of up to $500 for the first incident, $2,500 for the second offense, and $10,000 for any third and any other offense following the third offense. Employers will have a very short period to cure the first and second offenses before fines are issued, but there's no opportunity to cure these third or subsequent offenses. $10,000, guys. Amendments to the Illinois Personnel Records Review Act apply to employers with 5 or more employees. This was amended in a few different ways. First, the list of documents that employees have the right to request to inspect, copy, and receive copies of was expanded to include any employment-related contracts or agreements that the employer maintains that are legally binding on the employee, any employee handbooks the employer made available during the employee's employment and that the employee acknowledged receiving, and any written employer policies or procedures that the employer contends the employee was subject to and that concern qualifications for employment, promotion, transfer, discharge, compensation, benefits, or any other type of disciplinary action. Next, the request must now be in writing. It is no longer at the employer's discretion to require it to be in writing or not. The act was also amended here to provide the proper method of making a request. Third, an employee's trade secrets, client lists, sales projections, and financial data was added to the list of documents that are exempt from the employee's right to inspection, which employees now don't have any right to any of these exempt documents and information. Fourth, if an employer does not maintain records in one or more of the required categories of documents requested, the employer may respond in writing notifying the employee that the employer does not maintain records in that category. However, the employer must still permit inspection, copying, and receipt of copies of any other category requested, to which the employer does maintain those records. The request may now be made in electronic format, which includes emails and even text messages. So if an employee is requesting to see their personnel records over text message, that counts as a formal request, as long as they provide or include what exactly they are requesting. Sixth, the employer may still charge a fee but this fee is limited to the cost of duplicating the requested record and cannot include any imputed costs of the time spent duplicating, the purchase of rental copy machines, purchase of rental computer equipment, purchase, rental, or licensing software, any other similar expenses. So it's just purely the cost of duplicating without additional costs. Finally, an employee may still commence an action in the circuit court to enforce the provisions of this Personnel Review Records Act. But if an employer is alleged to have violated the act, only after the Illinois Department of Labor has failed to resolve a complaint within 180 days, the department or the department certifies in writing that it's unlikely to be able to resolve it, the suit can be filed in a circuit court. So it has to go through the Department of Labor first. Next, we have the new Illinois child labor law. Illinois repealed and replaced the existing child labor law. The new law, which applies to minors age 15 or younger, introduces changes to the hours minors are allowed to work, specifies additional prohibited occupations for minors, and adds a provision prohibiting discrimination and retaliation. It also calls out minors 13 years old and younger as those who may not be employed in any occupation or at any work site unless explicitly authorized or exempted by the Act. Next, we have the amendments to the Illinois Right to Privacy in the Workplace Act. These amendments created several employment protections for individuals when employers do use the federal E-Verify system. So employers that continue to use this federal E-Verify system must now incorporate new requirements into their employment verification practices so that they do not impose work authorization requirements that are greater than those required under federal law. And they must now provide a notice to each current employee and their authorized representatives, if any, by posting in English and in any language commonly used in the workplace, a notice of any inspections of I-9 employment eligibility verification forms or other employment records conducted by the inspecting entity within 72 hours after receiving notice of the inspection taking place. On or before July 1st, 2024, the Department of Labor should have developed a template for this notice, and it should be available now on their website. Next, we have the Illinois Worker Freedom of Speech Act. This is new. It prohibits employers or an employer's agent, representative, designee, etc., from discharging, disciplining, or penalizing, or threatening to discharge, discipline, or penalize, or take any adverse employment action against an employee for declining to participate in certain employer-sponsored meetings on religious or political matters. Okay, so now additionally, employers must post and keep posted a notice of the employee's rights under this new Illinois Worker Freedom of Speech Act, where employee notices are customarily placed within 30 days after the effective date of January 1st, 2025. So by the end of this month, we need to post another notice about the Illinois Worker Freedom of Speech Act. Aggrieved employees may bring a civil action to enforce any provision of this new act within 1 year after the date of the alleged violation. In addition, employees may also file a claim with the Illinois Department of Human Rights within 3 years after the alleged conduct. The employer will be assessed a civil penalty of $1,000 for each violation payable to the department, and each employee who is subject to a violation will constitute a separate violation. Next, we have the updates to the Illinois Military and Veterans Status Protections. while there's a good amount of measures that have taken place, new measures taken place or set in motion impacting veterans and their families, we only have time to discuss a few. So I'm going to go over just a few of these. The Illinois Statute on Statutes was amended to expand the definition of armed forces or uniformed services to include the U.S. Space Force for purpose of employment protections for military service members. Additionally, the Illinois Vital Records Act was amended so that death certificates can now include details about a deceased military service, helping families access survivor benefits. Third, the Employment Department of Veterans Affairs Act requires the Illinois Department of Veteran Affairs and the Illinois Department of Labor to create and make available at no cost a poster highlighting free veteran benefits and services. You will need to double check to see if this notice poster is something that needs to be posted in your workplace. The Illinois Consumer Fraud and Deceptive Business Practices Act will now include updated disclosure requirements to ensure veterans are fully aware of their options and that all county veteran service officers are VA accredited. It is now an unlawful practice for any person providing veteran or military benefit services to fail to clearly provide, both orally and in writing, veteran services disclosures when veteran or military benefit services are provided in exchange for any financial compensation, benefit, or thing of value. And then I'll hand it over to Maura Ann to discuss the amendments to the Illinois Insurance Code or benefits.
Wow, thank you very much, Madeline. There's been a lot of activity on the Illinois front. I have to admit that the activity on the federal level has been very quiet at the moment. So I do want to talk a little bit about some of the changes that Secure 2.0 provided to retirement plans. I wanted to talk about the fact that the annual employee deferrals to simple retirement plans, simple IRAs, has increased to 16.5. That's a new change. The catch-up limit for those 50 and over remains the same at $3,500. The new catch-up contributions amount increases to allow employees age 50 and older to make additional deposits into their tax-advantaged retirement savings accounts. Now that we're in 2025, there is an increase in the catch-up contribution limit for participants who have reached ages 60 to 63. It does not apply to somebody who is 64 or 65, unfortunately. The new 401k plans established on or after December 29, 2022 are required to implement an automatic enrollment feature in 2025 unless an exception applies. If you inherited an IRA from someone who died on or after January 1, 2020, you are required to withdraw all funds in the IRA no later than December 31 of the 10th full calendar year following the death of the individual from whom you inherited the IRA. That is new. That's a new requirement. The IRS delayed the implementation of the final rules governing inherited IRAs and the required minimum distributions until 2025. However, the IRS has provided transitional relief for beneficiaries who did not take their RMDs from their inherited IRAs in 2021 through 2024. So starting in 2025, however, there's a 25% penalty assessed for those who do not take their RMDs, their required minimum distributions in that year. The Secure 2.0 Act also created a searchable database to help people find lost retirement benefit accounts. The Lost and Found database is found at the Department of Labor. That's DOL.org. I wanted to mention two other things. The cost of living increases can be found at Notice 2024-80. That's the IRS notice that provides for the cost of living increases. Also, I wanted to just mention quickly that the annual compensation limit for 401ks is now $350,000, and the Social Security wage base has increased to $176 on $100. So it's $176 and $100. After 22, a plan may provide that the employer contribution or the non-elective contributions may get Roth treatment. That is important. Now, that is an employer option. So you don't have to do it, but you are able to do it. Then I want to talk about the Federal Social Security Fairness Act of 2025. President Biden has signed the Social Security Fairness Act into law. The act repealed two federal laws, the windfall elimination provision, the WEP, and the government pension offset, GPO. The WEP and GPO reduced Social Security payments to many public sector retirees and survivors who receive benefits from a public retirement system for employment that did not require contributions to Social Security. By repealing the WEP and the GPO, these public sector retirees and survivors' Social Security benefits are no longer reduced. So their benefits will go up. The Social Security Fairness Act applies to Social Security benefits payable after December 2023. The Social Security Administration is preparing for implementation of the law and will publish more information on their website as soon as it is available. There also have been amendments to the Illinois Insurance Code. With regard to the insurance coverage for all individual and group policies, the Illinois Insurance Code has been amended to, one, extend hearing and insurance coverage to all ages rather than just to those under the age of 18. Two, require insurers to cap the insurer's cost of epinephrine twin packs at $60. And three, to ensure that brand name drug insurance coverage when generic options are unavailable due to supply issues. So you have to ensure that the drug insurance coverage is available if the generic options are not available. That may increase the group insurance coverage costs for employers. Who knows? Hopefully it won't. And then now I'll turn it over to Andy with respect to some more increases to the federal laws.
Thank you, Moran, and thank you, Loyal Diners, for staying with us through this point. And as Moran said, there's not a lot of change that we can forecast with certainty because labor laws haven't been at the forefront of the new administration's day one agenda. However, I think that employers may need to fasten their seatbelts and anticipate a more uncertain ride over the next 4 years. And they shouldn't assume that this will be a reprise of President Trump's labor policies during his first term. And why would I say that? Well, let's take a look at what I think was the most surprising nomination among the roster of cabinet nominations made by President Trump. And that is his nomination of former Republican Congressman Lori Chavez DeRemer of the state of Oregon to be Secretary of Labor. Now, I would not have been surprised if President Biden had nominated Ms. Chavez DeRemer to be Secretary of Labor. I would not have been surprised if Vice President Harris, had she won the general election, had appointed Ms. Chavez DeRemer as Labor Secretary. I have to say, I was quite surprised that President Trump has advanced this particular person to be Labor Secretary, particularly when we juxtapose her selection against her predecessor during the Trump administration. The Secretary of Labor during President Trump's first administration was Eugene Scalia. Eugene Scalia was a very powerful and effective labor secretary, bringing decades of experience as a management side, employer-friendly person who advocated strongly for employers who wanted to make a day-to-day business life as easy as possible and to restore some fairness to the workplace. Based on what we know so far, and the track record is not as detailed as we have with Gene Scalia before his nomination, we know that Ms. Chavez DeRemer was a one-term member of Congress. She was elected in 2022 and lost her campaign for re-election in November of 24. Her House biography describes her as a small businesswoman who, with her husband, who's an anesthesiologist, founded an anesthesia management company and they operated and owned several other medical clinics in the Pacific Northwest. She was mayor of Happy Valley, Oregon, between 2011 and 2019 before running for Congress. And when she ran for Congress, she was endorsed by the Teamsters Union. And those of you who follow the political scene closely will remember that Teamsters president was invited to speak at the Republican convention and was given a prominent role in the convention. So her appointment may be a reflection of the kind of quiet, soft support that the Teamsters Union provided to the Trump-Vance campaign in the last election. But here's where she really stands apart from a typical Republican nominee for this position. In 2023, she was the only Republican congressperson to co-sponsor and one of only 3 Republicans to vote for the Democrat-led Protecting the Right to Organize, or PRO Act, which was strongly opposed by business groups across the country. The PRO Act, if enacted, would amend the National Labor Relations Act to give workers additional advantages when bargaining and when organizing or joining unions. It would also undercut state laws, such as laws that are in place in Texas and Florida and throughout the South that effectively discourage union organizing. And President Trump, in fact, vetoed an earlier version of the PRO Act in 2020. So this really makes her stand out, and I think causes some of us to think that, perhaps this might be a different labor path to follow for employers than businesses really enjoyed during the first Trump administration. We haven't seen any real opposition to her candidacy, and we expect that it likely will be approved by the Senate. Now, if she does take over this role, it's going to take over an agency that really, under the Biden administration, proposed sweeping changes to wage and hour, workplace safety and health, independent contractor classification, and many other regulations, most of which were opposed by the business community, and many of which were struck down by the courts. Now, there's a couple of appointments that will follow, probably sometime between now and early February, and that is who will be the general counsel of the National Labor Relations Board, because this is a really important appointment. And we expect that President Trump will immediately terminate, as is his prerogative, the current general counsel, Jennifer Abruzzo, who has really antagonized business with some very, very oppressive mandates and regulations. And so if President Trump were to appoint someone with a more traditional Republican management side background, that may be a signal of a return to Republican normality. But if he picks someone more aligned with Ms. Chavez de Remmer's background, again, it could be very interesting. I want to talk briefly about the status of some laws. There will be an increase in the minimum wage for certain government contractors. Not a really big deal. It's going to go from $17.20 an hour to $17.75. But then let's talk about a couple of issues that were so important in the last couple of years that we actually devoted a couple of our luncheon programs. The FTC non-compete ban, the updated rules for minimum compensation to qualify as an exempt employee. Well, to borrow from the late, great Gilda Radner's character, Rosanna Dana, never mind. Not going to happen. Courts have stopped it. We might see something new. In fact, many people predict that in terms of the overtime salary rules, that the Republican administration will likely find a more modest increase to the current minimum of $35,568 a year, but that remains to be seen. I realize we're at the top of the hour, and there are a number of Illinois state rules that, frankly, some of our clients, some companies haven't really tackled yet because they're pretty onerous. Don't forget them. They're listed on our slide along with City of Chicago rules. So make sure that you are mindful of your employment compliance checklist. And with that, I'm going to turn the program back over to Amy.
Thank you, Andy, and thank you, Maura Ann and Madeline, for giving us a lot of information today. And as I mentioned up at the top of the webinar, that we will provide all attendees with a copy of a more detailed deck with the information we went over, as well as some bonus information we didn't get a chance to cover today. So watch your inbox and our social media pages for details on our next webinar, and thanks again for joining us.